Good day, everyone. Welcome to our day 4 of OVIP. Hope we're all doing great. Good day, everyone. I am Okosa Chinwendu Cynthia, your host for today's section of the Omaplex Virtual Internship Program, OVIP. I trust you all are I trust we're all having a great day. So before we dive into today's section of the OVIP, I would love to hear from a few of you. Maybe one or two persons can kindly share how the internship has been going and the impact it has had on you since we kicked off on Monday. Hello, Gillette. Please, can we hear you? Unmute your mic. You can go ahead and speak. Okay, gentlemen, please give us some few minutes to sort one or two things out. We'll get back to you people.
Hi guys, good afternoon. Your mics are enabled, so you can disable to make your contribution. Thank you.
Okay, hello, Miss Juliet. You can go ahead. Miss Juliet, can you hear me? I'll move to the next person. Hello, Mr. Jonathan. Please, can you unmute your mic and say something with the stuff you've learned all this while that the OVIP internship has been going on, the impact you've made on you so far?
All right. Good afternoon, everyone. Can everybody hear me?
Yes, sir. Yes, sir.
Okay.
Mr. Jonathan, go ahead. We can hear you.
My name is
Yes,
Akuweze
we hear
Jonathan
you.
Munakimko, a student of Alektukweme Federal University, Ebonyi State, Nigeria. So far, the internship has been a very wonderful experience, ranging from our topic, the topic we learned on the first day, which was corporate governance, down to ADR to sports law. It has been a roller coaster, and I can't wait for what OVIP 2025 would have in stock for us going further. And it has exposed me personally to new experiences, new things I didn't know before in law, and also to understand, or for clarification purposes, so many things that I have been able to understand that this internship has also made it clear to me. Thank you.
Thank you so much, Mr. Jonathan. Hey, good day, Miss Mercy. Can you hear me? Please unmute your mic. Hello, Miss Mercy. Good day, Mr. Tochukwu Franklin Obiefuna. Can you speak?
Yes,
Mr.
a very good
Tochukwu.
afternoon to all of us.
Good afternoon, Mr. Tochukwu. Go ahead and speak.
Yes, good afternoon once again. My name is Toshiko Franklin Obiefuna, a graduate of Nnamdi Azikiwe University. So I must really commend the organizers of OVIP so far, because the experience has been wonderful. Starting from Monday when we learned about corporate governance, it really opened my, eyes and my mind to a whole lot of opportunities that are out there in the corporate world, and some of the intricacies that are involved with um, corporate law that I haven't really heard about before. And then on Tuesday, when we learned about dispute resolution, ways by which we can resolve disputes by way of litigation, as well as arbitration, it was really eye-opening, because the speaker made it a very interactive session, and it was fun getting contributions from other interns, and the questions that he was throwing at us. It was really a fun experience. And going to yesterday, like, for me, I think for me, yesterday was actually my highest points when we spoke about sports law. I have always known that in law the sports is also involved, but I never knew that it was to this extent. And the whole lot of opportunities are out there for one to explore in the world of sports. So it has really been eye-opening, and I look forward to today's session talking about the alternative dispute resolutions session that we are going to have today. Thank you very much.
Okay, thank you, Mr. Tochukwu. Okay, let's take one more person, then we move ahead. Okay, Mr. Debayo, please, can you unmute your mic and talk to us? Okay, Ms. Adeze. Ms. Adeze, can you unmute your mic and speak to us? Okay, can you unmute? Okay, go ahead.
Okay, so what I've learned so far in the session, this is my first internship, so I would say it's like it has been very, very good for me, because I've learned a whole lot. So firstly, the day one, we started with Miss Barisa Odwaka, I don't remember her name. She asked us a question about corporate scandals. I knew what corporate scandals is, but I didn't really have an answer. But after that session on corporate governance, I got to understand that those corporate scandals that we have is due to the lack of most companies not, adopting the practices stipulated in the Company Allied Matters Act, most of them not knowing their responsibilities and how the roles of company secretary and director helps to ensure that a company runs through good corporate governance, them ensuring that they have a fiduciary duty that is putting the interest of the whole company and the stakeholders at hand. I got to understand the ethics that are necessary for a company to be a good corporate governance. Then from day two, we did a rundown on ADR and litigation. There I got to understand that everything is not really about litigation. That actually made me to have at least a little passion for, I'll put my eye into ADR because I thought that everything is actually litigation. But then he taught us that there are some certain things that you need to consider before you tell your client to go to court. There are some things like party relationship, the confidence, if there's any secret or anything, there are things you have to consider. And I got to know the differences between the classes of ADR: negotiation, mediation, conciliation, arbitration, etc. Then we now moved into litigation. There I got to understand the differences between the Federal High Court, State High Court, and National Industrial Court, them having concurrent jurisdiction. And we also went into talking about examination of witnesses, in the sense that if a witness admits his statement on oath in court, it becomes an evidence. And that's like the main difference between a statement on oath and an affidavit. We also did a rundown on many other stages in litigation. Then on day 3, we also did sports law by our two sports enthusiasts. Yeah, I got to even have an overview of sports law because I was not the type of person that is interested in sports law or anything. There we got to understand, even you being a sports law, you have to have a general knowledge of company contracts and everything. But then after knowing the general knowledge of law, like in company contract and everything, then you have to know the specific regulatory laws in sports law. Then you talked about the Court of Arbitration, which is the highest in Switzerland. We also talked about the National Dispute Resolution Chambers and many other things. And you talked about the fact that the reason why Nigeria is not doing so well in sports law because most of the sports clubs are not really they're not really, putting into consideration the necessary laws, registration of players and everything. So that's just it. And I think today we're moving on to ADR, the key sector. So that's it. Thank you very much.
Ms. Adeze, wow, that's impressive. Thank you so much for your wonderful contribution. Okay, gentlemen, let's not forget that OVIP is not just a webinar. This is an internship program, and that means full and active participation is key. We want every section to be highly interactive, engaging, and impactful. So, gentlemen, I believe we are all set. Our today's guest speaker is ready to take us through our OVIP section for today on ADR, Alternative Dispute Resolution. It is my absolute pleasure to introduce our distinguished guest speaker for today's section, Barrister Lillian Eku. Barrister Lillian Eku is a dispute resolution lawyer at Omaplex Law Firm, a seasoned dispute resolution lawyer. She brings expertise, passion to the table, with a strong background also in intellectual property. Gentlemen, please unmute your mic, please. She brings expertise and passion to the table, with a strong background also in intellectual property law. She provides innovative solutions for clients navigating complex IP rights. She has bagged several achievements and credentials, including being a chartered mediator and conciliator, a member Institute of Chartered Mediator and Conciliator, making her very skilled as an alternative dispute resolution lawyer. She's also a member of the Legal Entrepreneurship Committee of the Nigerian Bar Association, where she has been actively involved in initiatives promoting entrepreneurship and innovation in the legal profession in Nigeria. She has obtained multiple intellectual property certifications, that demonstrate her expertise and commitment to staying up to date in the field. Barrister Lillian Eku is a proud member of the World Intellectual Property Organization, WIPO, where she has engaged with international IP experts. Thank you, guys. So, gentlemen, with such an impressive profile and a wealth of experience, I have no doubt that today's section will be both enlightening and impactful. So, gentlemen, please, with your emoji, claps, and warm greeting, let us welcome our distinguished guest speaker for today. Barrister Lillian Eku, it is truly an honor to have you with us. The floor is 9 years.
Good morning, everyone. It's a pleasure to be here today. Good morning, good morning. I see we have a lot of people here, and it's impressive to have such number of young lawyers, students who are very eager to know a lot. I used to say that this is our profession. In fact, you know, when people graduate, they will be like, even signboard, I will not read. Unfortunately, in law, you keep reading. In fact, as well, our lawyers right now, I'm sure you notice that they've introduced this CPD point, that is continuous learning. So it is now mandatory, say, for us to even get our seal the next year, for us to keep learning. So the learning never ends. We learn till old age. So I'm glad when I see our fellow young stars who always want to learn and know more, because the truth is that knowledge is our asset in this profession, and that is what we have as capital to give out. So we keep learning, just like how the Igbo people will go and buy goods. We need to acquire more knowledge to give value to the clients out there. So to this topic, you know, ADR, I think ADR is one of the area that I know that people keep talking about it, even in school. In fact, in law clinics, I was the head of department for the ADR department, the ADR department. So they've been talking about, I'm sure that everyone here, I don't believe that there'll be any law student that will not know what is an ADR, even before the previous session we had on dispute resolution. I know almost everyone knows what an ADR is. So briefly, just like she said, this is an internship. It's not like it's a webinar. So internship, we engage the interns. We want interactive session between you and I. So you all will also talk at intervals. I'll ask questions so that it will be very engaging, because it's not like, I don't want it to be like, okay, I'm coming to present a paper. It's not a presentation. It is a talk. It is a speaking, like I'm just like teaching basically, and I want it to be very interactive. So first of all, I will start with, what do you think ADR is about? I know my slides have been shared, but you mustn't give me what is my slide. From your own understanding, what is ADR, and why do you think ADR is even necessary as at now? So let me hear from you, just like two people who will tell me what an ADR, what ADR is, and what you think is the importance. Why do you even think that ADR is even necessary? So let me just hear you briefly before I go on. Okay.
Adebayo, Mr. Adebayo, please, can you speak to us? Mr. Adebayo, can you unmute your mic and speak to us? Go to
Emma, okay.
Please, let's make this snappy. If you want to speak, just unmute. We mustn't call your name because we cannot all
Good morning.
call everyone.
Good
Yes, so
afternoon.
thank you.
Good afternoon. Good afternoon. Sorry. Good afternoon, ma. Good afternoon, ma.
Please go ahead.
Okay. My name is Innocent Easy. I feel like AGRE is important because of it offers the parties involved in a suit other aspects in order to resolve it, and it helps them save time, helps them prevent litigation, because most times litigation takes a whole lot of time. Sometimes it takes a couple of years and matters are not resolved. So EDRA helps parties to come to understanding, and also involves a third party to broker more understanding and make sure the both parties involved in the case comes to terms and everything is agreed in both parties' favor and the matter is resolved smoothly.
Okay, good
Good
Thank you,
afternoon.
Mr.
afternoon.
Jonathan, for your wonderful contribution.
Good, af-
Good
Okay.
afternoon.
good afternoon. My name
Okay,
is
Good
please.
afternoon.
Okenna Judith Ogochukwu
Okay,
from
Ogochukwu, go
Nnamdi
ahead.
Azikiwe. Okay, thank you, ma. I'm from Nnamdi Azikiwe University, Oka. Concerning ADR is alternative dispute resolution. So it's like the a kind of an aspect of resolving disputes apart from litigation, and it really helps parties to come to a common ground instead of going to court and maybe taking long time, years to resolve a particular dispute. They can just resolve it within a matter of months or even weeks. So, and it really make them not to quarrel or see themselves as enemies, just like litigation does. Because once you go to court, just consider yourselves as they normally don't come back as friends. It has been happening. So that's why I prefer that ABR is better, because they will come back and still see themselves as friends, or because they have reached an agreement or they now have understanding. Thank you.
Okay, thank you, Ms. Ogochukwu, for your wonderful contribution.
Thank you. Oh, okay. Well, let me just not cut you short. The person that just greeted now, I will give you just like a minute or two before I go on. That will be the last person. So you can go ahead.
Thank you very much, Ma. My name is Manuel Saus-Nekoneke. I'm a recent graduate from the prestigious University of Arbitration University. So ADR simply means alternative dispute resolution. So it's it's the method of resolving conflict outside of court, and it's always encouraged because it is faster, cheaper, and it is a very flexible process other than the traditional litigation. It's very important because it helps reduce the cost backlog and save time and money. And like it has been mentioned before, but I'll just also emphasize on this point, it preserves relationship, and it has been encouraged because of its creative solution. It's one of the most, not the most, but it's a very creative future in the legal aspect, especially in the world. Thank you.
Okay, thank you. So, like, without wasting much time, I will have to go in with the topic for today and continue with a brief introduction about the topic and then move forward. Thank you all for your very, very beautiful. I said it that a lot of people know about ADR because it's something that has been coming up due to the delays, the cost, everything that affects litigation. People are gradually shifting towards the alternative way. People even call it appropriate way, different things they call ADR. And so today's topic, that's what brought me to even thinking that, okay, yes, ADR is a thing, but are there some areas, then what are the key sectors that you will see that ADR is most functional? Because the truth is that in as much as we say ADR is good and all, yes, there are some disputes that needs to be litigated upon, and there are some key sectors for ADR that there are some sectors that ADR comes up way more often. Like ADR is like the first resort before you even think about litigation. So that is what brought us to this topic. And this topic is an area that I think people don't really know much about, because yeah, there are some areas, there are some key sectors that you need ADR for, even before the court. It's only when the ADR doesn't work, then you now go to court. So let me just briefly read it. I've already prepared everything now. So there are several areas like arbitration. Arbitration has become cornerstone in resolving commercial and investment disputes. That's why you see most of these commercial firms that deals with more companies, or even in their contracts, you see they have their arbitration, that the dispute must be resolved through arbitration. When we go further into the topic, you will know the reasons why commercial disputes and in most people, corporates, usually like the arbitration method, they like the ADR. The main thing is to actually safeguard their business and for confidentiality reasons. Mediation is mostly resorted to in families. You realize that when you have couple disputes, they can't go to court and be saying everything there, because you know one thing with documents, the court is a public place and no one really wants their personal affairs to be somewhere you now go and get CTC of my mom's statement, my mom's WhatsApp message. So you understand all those kind of things. So that is why ADR is most important in this sector. Like arbitration, they resort to it often in commercial disputes. Then family, people do mediation. I will go further to explain what mediation is. This is just like an introduction. Then several other things we have in labor too, labor contracts and all. They do mediation way more often. Then also, ADR is way more important in intellectual property segment. You know, intellectual property deals with property of the intellect, those things that are not even visible. So when you are going out, sometimes there are ideas, and you know, it's not every idea that comes out immediately. So when you have an idea, you guard it. And most often, because the court is a public space, disputes like that, they want it to be they want it to be secluded from the crowd, just to preserve their own asset, because their asset is their ideas, their asset is their intellectual property. So dispute like intellectual property, also ADR is like the first resort. So those are like the key sectors that ADR is needed for. This sectoral approach to ADR is significant because each sector presents unique challenges and dynamics that require tailored solutions. ADR offers not just a means of dispute resolution, but also a way to preserve relationships. Someone said that, which is very correct, to preserve relationship, protect confidentiality, and promote economic stability. Because the truth is that if you go and say all your secret and you don't know who is even your rival in court, that will just come out before you know they may not use the same name, but they will trade in your style, which will be detrimental to your own business. So these are the basic things. This is what this topic will basically talk more about. So let me just give a brief meaning of the ADR generally and the scope. So ADR stands for Alternative Dispute Resolution, which refers to process, techniques used to resolve dispute outside the traditional litigation. So the goal is to provide flexible, less formal, and more cost-effective mechanism for dispute settlement. So people call it not just alternative, some people call it appropriate because it complements and competes with the court procedures. So what are the importance of alternative dispute resolution? So just like some people have stated it earlier, they said litigation is often criticized. It is time consuming. There's a case I've been going for like 2021, and it is a very small case. So I understand the reason why people don't even really want to take this long technique, because it delays time. And you know, in the Nigerian system now, we're in the new legal year, because the court, once your case of say reaching June, you may not even be sure of that year again, because from June, they start giving you adjournments, which will be in October after the court vacation, because judges go for 3-month vacation. It's just now the courts are started resuming again. So because of all this slow system, because of if they are going for Salah break, they take 2 weeks. If they are going for Easter break, they take 2 weeks. And all these religious things, all those things take the time of the court. Then the long one is a vacation. So it is time consuming. It takes a lot of time. That is the reason why ADR is most appropriate in disputes. Also, confidentiality. Disputes can be kept private, unlike public court proceedings. Then preservation of relationships. I will tell you that sometimes, it's just like, I don't know if you've seen some of all this comic they do online. They'll be like, oh, I'm a divorce lawyer, and then I came to court, my 2 clients were Ankara. It is funny, but it is true, because sometimes these people can actually come together if they use the alternative dispute resolution. That's if they use a mediator, if they use a conciliator, because mediation is the most appropriate for family, because when someone comes in to just see what help the 2 parties, I will define mediation so you will know basically what it is. So mediation basically is you just help the 2 parties resolve. But when you go to court, maybe they still love themselves, and they even try to, because sometimes all these disputes are just little misunderstanding. But when you go to court, it's like you are in the war zone. So you can even hardly come back after going to court, because the man will have to talk about his ego, his properties are already out there, his messages, everything now is in the open. So even if they were going to resolve before, because of the way it's all looking in court, they can no longer resolve. So one of the things important is that it preserves relationship. It preserves relationship. There's a confidence who just hears them and helps them to resolve, and expert decision making. Parties can appoint arbitrators or mediators with expertise in subject matter. So let me talk about the types of arbitration. After the types, I will leave the floor open to hear. I will ask a few questions also, so just be ready, be attentive as I am also talking. So you can, I will want to be getting questions bit by bit so that we'll follow up. In case you didn't get the first part, I can actually make it, I can elaborate on it before we go for that, so we'll keep in track. So arbitration, I know people know what's arbitration, and just like I said, it is most appropriate in the commercial segment. People use it most of commercial dispute. In fact, in their contracts, they always say there will be it will result to arbitration. Why? Because they don't want the long process. Because sometimes when you go to court, these commercial companies and corporate institutes, most of their disputes are tied to financial. It's tied to finances. So when you go to court and there is a delay in court, it affects the finances of the company. That is the reason why they just want to resolve to an arbitrator who will just give them the final say and they move forward. So what is arbitration? It is a private, formal, and legally binding method of dispute resolution where parties submit their disputes to a neutral arbitrator or panel. Most time what happens is that this party will bring one person, the other party bring another. So they can be, if there are 2 parties, or if there are 3 people in the dispute, or there are 2 companies, one company should bring, just for it to be neutral, for the judgments to be general. They can bring random, then 2 of them can both elect one person. So if some people can choose to have 3 arbitrators, one arbitrator from the first party, the other from the other party, then 2 of them can both appoint one arbitrator. So this one has a binding effect because it has an arbitral award, which is the final thing that you receive after you've resolved the dispute through arbitration. So it is governed by the Arbitration and Conciliation Act, Cap A18, LFN 2004, and recently influenced by state-level laws such as Lagos State Arbitration Law. So what are the key features of arbitration? In the decision, it has an arbitral award, which is binding and is enforceable like a court judgment. And parties can choose arbitrators with expertise in their field. Why it is also good, because sometimes when you go to meet a judge, sometimes the judge is not skilled in that particular area. But when you have the liberty to choose an arbitrator, a mediator, like you have a family mediator, you can have a family so this person is grounded in that subject matter you are giving him. So when you go to arbitration, they are corporate arbitrators, people that know these things. So you can have the liberty to choose the type of arbitrator you want, who is skilled in that area of dispute, and then you get a good say, then you get a good arbitral award. That shows he's grounded. Unlike the court system where you don't, it's just general. They will just give a general award or a general court judgment. So that is one of the features of arbitration and the definition of arbitration. So what is mediation? Mediation is a voluntary. This one doesn't have a binding effect. It's a non-binding process where a neutral third party, which is the mediator, assists. So I want you to pick their keywords in this definition. I will ask it later. Their keywords. So mediation is a voluntary non-binding process where a neutral third party, which is the mediator, assists. They assist disputing parties in reaching a mutually acceptable settlement. Mediation is commonly adopted in family disputes, commercial disagreement, and workplace issues. You can see the similarities in all these things. These are issues that from family, it has, family rules, and or they don't want to take it outside, commercial disagreement for financial reasons, workplace issues, because they don't want to really talk about their work rules that are just should I say, they are unique to that workplace. That's the reason why they don't want to resort to the public settlement. Workplace issues most times is even the head of the company that can serve as a mediator to assist the two workers to resolve. So because they don't want to take it outside and then spoil the name of the company or the law firm or whatever it is. So that's where mediation comes. So what are the key features of mediation? Mediation is informal, flexible. It focuses on the interest rather than legal rights. It's not that you say, oh, who won? They really want to understand that, yes, in court, they'll be like, oh, this one is a bad person, this one is a good person, this one is this one is that one. But in mediation, the mediator has come to understand the two sides. When you understand the two sides, you can now say, okay, this is it, and help them. When you now elaborate on the issues, then you help the two of them to resolve. That is who a mediator is. Assist the two of them into bringing an amicable settlement. So the parties retain control of their outcome. What are the advantages? It preserves relationship quicker and less costly than arbitration or litigation. So what are the limitations? It's not binding unless parties voluntarily enter into a settlement agreement. And of course, when you have an agreement or a contract, it becomes binding. But otherwise, the thing is a non-binding dispute resolution. So conciliation. Conciliation is similar to mediation, but with a slightly more interventionist role by the conciliator. And if you see the definition I gave in mediation, you will see the slight difference. The conciliator who may suggest possible solution or settlement. So in the mediation, they assist two parties to come. So, but in conciliation, they suggest, they can bring out the things that they think that is going to help this dispute. So they bring out possible solutions that will aid the settlement. But it is actually non-binding, but this is the difference. They bring out solutions. They suggest a lot of things that can help the dispute rather than leaving it for the two of them to resolve. So legal framework of this is provided under the Arbitration and Conciliation Act 1988. So what are the key features? Key features use. Please unmute your mic. Yes. So the key features of mediation, of conciliation, sorry. It is used in commercial and labor disputes in Nigeria. If you find out most of all this labor congress and all, you will see when they always try to have this meeting with either the minister, sometimes they even go to the president, you see this ASU union, it's conciliation they try to do. They try to come together And then they will bring they suggest possible solution. Someone will suggest possible solution as to how they can resolve their disputes. So those ones, they hardly want to go to court just so they can have amicable settlements. So it is the conciliator helps clarify issues and propose practical settlements. What are the advantages? It is structured but still less adversarial than litigation. So like mediation, it is non-binding until the parties agree to term. So we also have the negotiation, which is the last one before I open the floor for interaction and questions. So negotiation, what is negotiation? Negotiation is a direct and voluntary dialogue between parties. This one is, you don't need the help of a lawyer, or it doesn't need the help of a third party. It is between the two of them. The two of them come together. This one happens most time in family. It is they do it more because, family, first of all, aside religion, tradition, emotions also in relationship, this happen when there's a dispute between two people, when you talk about spouses and all. It's not always good to bring a third party. So negotiation is when two of them come together and see what is the issue, what is the issue. They share, they rub minds together and resolve. So this is the most basic and informal ADR method, no third party. So what is the advantage? It's fastest, cheapest, and completely confidential because no other person will hear about your dispute. Two of you will resolve it. So I will stop there, and I will want, first of all, before I ask question, I would like to hear contributions, and before I ask questions. So I will take like 3 contributions and what you have to say regarding this. If you have a question, Sue, before I ask my own question. So the facilitator will take over from you.
Okay, gentlemen, if you have any question, you can indicate by raising your hand. Okay, Mr. Olatunji, please unmute yourself and go ahead and speak.
Good afternoon, everyone. My name is Olatunji. I really want to make this contribution as regards to the abstract of the refugees. Is it actually the law that is in
Mr. Olatunji, please, can you speak out? We can't hear you.
Okay, I said about the law that she cited, the Arbitration and Mediation Act. Is it the 2004 that is in existence, or the one of 2023? I just want to make clarification on that.
Okay, Mr. Olatunji, I'm going to take another person's question before our guest will respond to you. We'll respond together. I think she's having some network challenge trying to connect. Miss Lillian. Miss Lillian, can you unmute your mic and speak to us? Miss Lillian, can you unmute your mic and speak to us? Miss Adeze, please unmute your mic and speak to us.
Okay, so my question is, I wanted to ask, this award in arbitration, is it like the ruling of the arbitrator or the benefit that any of the two parties will receive after they come to a common ground after resolving the issue?
Ms. Adeze, please repeat your question. You are too fast.
Okay, sorry, I'll take it down. I said this award in arbitration, is it like the ruling, like a judgment to court? Is it like what the arbitrator, what he says, between the two parties? Or is it like the benefits that one party will receive from the issue after the issue has been resolved?
Okay, Miss Adez, I've taken down your question. Let me go to the next person. Miss Lillian, can you unmute yourself and ask your question? Okay, Aniekwe Esther, please go ahead and ask your question. Miss Aniekwe Esther, please can you go ahead and ask your question?
Good afternoon, ma.
Okay, good afternoon, dear. Please go ahead.
Okay, I wanted to ask, the last type of arbitration she mentioned was negotiation. And then she mentioned that the parties alone are the ones that are to do the whole talking and settlement by themselves. So my question is, if the parties alone are the ones doing everything by themselves, then why is it a legal procedure? Since it is the parties alone that do it by themselves, there's no form of legal personality there at the time when they do it, and they don't relate whatever they do to a legal personality. So that's my question.
Okay, thank you, Miss Esther. Let me take the next person's question. Miss Lillian, can you go ahead and ask your question? Miss Lillian. Okay, Mr. Olatunji, please, can you go ahead and ask your question? Mr. Olatunji, please go ahead and ask your question.
Can you hear me? Can you hear me, ma? Can you hear me, ma?
Hello, good afternoon, ma.
Please mute yourself. Mr. Olatunji, go ahead and ask your question.
So I want to make clarification on the act on arbitration that she said. Is it the one that was enacted in 2023, which is the Arbitration and Mediation Act of 2023? Is it no more binding than the one that was ratified in 2004? So that's my question. Thank you. Sorry, ma, did you get the question?
I didn't get this person's question. So I would take the question from the first one. I think the first one and this last question is a bit similar. So yes, while I did not, there's an update on the act. Actually, the act I actually mentioned, Arbitration and Conciliation Act. It's still in existence, but then the arbitration part of that Arbitration and Conciliation Act has been added, a lot of things has been added. So for that one is the extant one. The new one in 2023 is Arbitration and Mediation 2023. So the added mediation and the one for conciliation, that Arbitration Act of that 2004 I stated, is still in existence. They still use that for conciliation. But for arbitration, because of the new thing they added, it is now the 2023 act that's being used. Thank you for spotting that out for me. Yes, for conciliation, the previous act is still in use. Therefore, arbitration in the 2023 act and the arbitration and mediation, the 2023 act is what is the extant rule on that. So thank you for pointing that out. So for the second question, what's the second question? So yeah, the second question on award of arbitration, so say whether they give to the two parties, the person asked the question. The award of arbitration is like the final verdict. Let's say the court judgment for court. That's as we talk about judgment in court, we talk about award in arbitration. So that award is like after hearing the two parties and they've gone through different things and all, then the arbitrator gives arbitral award. That's like they give the final say on what is going to happen and what's going to be binding on the two parties. So that's that about what an arbitral award is. So let me say, what's the third one? For negotiation, someone asked a question on negotiation. If the parties are the one, it's funny because yes, it is part of the yes, even if it is negotiation between the two parties, when dispute happens later on, like later on when they want to now go to court, it will be stated that negotiation happened. It is formal. No matter how informal it looks, it is a means of resolving dispute outside court. So that is why it is added as part of, yes, it doesn't have a binding effect. It is the two of them. Obviously, we've just tried to gather all the different ways one can resolve dispute outside court. So negotiation is part of it. Yes, you may think that you and your friend, after having dispute, when you call her and two of you are, it is negotiation that is happening. Yes, it is negotiation. It's just that you will say, hey, I've settled with her. That settle you're talking about, the fact that you called her and say, guy, let me talk about this issue. Or make we talk about this dispute. It is negotiation that has just occurred. And you can actually even cite it if the thing later goes to court. If it was a WhatsApp message people use, you can screenshot it and show that it is a negotiation that happened. If it was a call and you screen record it, that serves as evidence that negotiation happened actually. So that is why it is important for you to know that the little dispute you have, you just discussing it is very important. That is why it's always good, because in the society, we add all this as part of the things that makes the society sane. When you're able to resolve with your brother or your sister, if it is just small dispute, it is negotiation. So it mustn't have that big name. The little dispute you have with your friends, when two of you work together and talk about it, negotiation has happened there. So that is that about that question. So any other question, you can write it down in the Q&A. We'll take it later. Then I will ask you questions, like I said. What did you spot out as the basic difference between a mediation and a conciliation? Someone should say that. What's the difference between a mediation and a conciliation?
But can I take that?
Okay.
My name is Absalam Arafat. I'm a graduate student from Christian University. So the core difference that I was able to pick out from your definition from conciliator and mediation and mediator is that the conciliator makes a proposed solutions to the party to settle their disputes. However, the mediator only facilitates communication between both parties. The mediator does not propose solution. He just makes sure that both parties settle their disputes amicably by facilitating communication. Unlike the conciliator, which the conciliator proposes solutions. So that was what I was able to pick up.
Okay, that shows you are very attentive. So another person, let me see another attentive person.
Good afternoon, ma. Can I speak?
What's your name? Who is speaking now?
Innocent.
Okay.
So conciliation is binding, while mediation is non-binding, except an agreement is reached by the both parties. But conciliation is binding, and when an agreement is reached by both parties, they get an arbitrary award when it comes to conciliation. But mediation is not binding.
Good afternoon. Can I attempt?
Good afternoon, ma'am.
Can I attempt?
Good afternoon, ma. Can I speak?
So, ma'am, what I understood that the difference.
Gentlemen, please just indicate your hand if you want to answer, please. Okay, Miss Joy, please can you speak? Miss Joy, please unmute your mic and speak. Okay, Miss Oma, please unmute your mic and speak.
Hello, can you hear me?
Okay, speak out, please.
Okay. Mediation, the difference between mediation and conciliation from the definition given is that mediation is more like the third party neutral, assisting both parties to resolve their disputes. Like the mediator stands as a neutral to facilitate effective communication between both parties, but he doesn't go ahead to like involve himself in the party's business. Instead, he just stands aside and ensure that parties assist parties. The major word is assist parties to resolve their disputes, while conciliator takes a step ahead to propose settlements between the parties regarding their dispute. Like he involves himself in the parties' disputes and like propose a way that they could resolve their disputes. That's the major difference I spot within mediation and conciliation.
Thank you so much. That's a brilliant one. So we'll stop there for the this thing. I will ask another question. For the person that I had one answer and I was like, hey, are you sure it's not me that made the mistake or so? Because I think you mixed it up. Let me clarify you on that. You talked about conciliation having an arbitral award and all. Arbitration, from the word arbitration, is the one that has the arbitral award, and conciliation is non-binding. The two of them is non-binding, actually. Mediation is non-binding, conciliation is also non-binding. The only difference, just like what they stated before, is that while mediation, there's a third party, but the third party's work is just to assist the two of them to come into a resolution and finally settle. Conciliation, they only suggest, it also intervenes in the issue and bring possible suggestions on the settlement. So that is the basic difference between them. So I will just ask a little, because our topic basically is the application of the ADR on different key sectors in Nigeria. So the application, then I will now ask, because I stated it initially, why do you think that ADR is necessary in some sectors? Or what do you think is the reason why ADR has some specific areas that is most applicable in? So let me see who is following and who has been following the reasons why I stated that. Actually, there are some sectors that ADR is most effective in fact, it's like the first resort. So let me hear from you. And what are they? What do you think are the areas and why? So before I go over to giving talk.
Okay, Ms. Adeze, please can you speak? Ms. Adeze, please unmute your mic and speak. Mr. Innocent, please can you unmute your mic and speak? Mr.
Okay.
Innocent.
Yes, ma'am. I'm speaking now. So
Okay, please speak out.
one of the areas you said ADR is applicable in Nigeria is, I think, the commercial areas, like when it comes to businesses or companies which their business is always, or their dispute is mostly about finances, and where the companies don't want their finances to be out in the open, and so they make use of ADR in order to come to a resolution, so that they don't. And also, the more, if they take it to court, the more the issue lingers in court, the more the company loses money. So for companies, ADR applies to them.
Thank you, Mr. Jonathan, for your wonderful contribution.
It's innocent, ma. It's
Oh,
innocent.
Innocent. So sorry for that. Thank you, Innocent, for your wonderful contribution. God's favor, please can you speak?
Go
ahead and speak. God's favor.
Yes, ma'am. Can you hear me?
Speak out, please.
Okay, good afternoon, everyone. So from what the speaker has said, I can deduce that ADR will be most effective in areas like medical disputes, when it has to do with sensitive matters relating to patients and health issues, basically medical disputes, and also cross-border disputes where there will be issues relating to the particular laws that are applicable, or the forum to be used. Maybe if it's supposed to be done by litigation, which courts would be appropriate and stuff like that. ADR, particularly arbitration, would prove useful in those aspects.
Thank you so much for your wonderful contribution. Mr. Uzochukwu Uneze, please can you speak? Mr. Uzochukwu.
Good afternoon.
Good afternoon. Please speak. Go ahead and speak.
Aisha.
Gentlemen, please mute your mic. Gentlemen, please mute your mic. Miss Happiness, please can you go ahead and speak? Gentlemen, please mute your mic. Happiness, please can you go ahead and speak?
Good.
So whoever wants to speak, because I think some people will raise their hand, maybe they don't really know.
Okay.
Yes.
Good afternoon.
I go ahead.
Good afternoon.
Yeah, please.
Okay.
Good afternoon, everyone. I am Adeze and you follow me.
Okay, Adeze, you can go on.
Okay, so another difference that I spot, the reason why
Can
ADR is being used
can I
is
speak?
in cases of party relationships, in the sense in between families or between workplaces. ADR is mostly used so that family secrets or between couples, or even secrets of companies cannot be disclosed outsiders. Because another thing is that most judgments in litigation is more strict, so it can actually affect the relationship after the ruling. So ADR is often used in families to ensure the party relationship and workplaces. Thank you. And it's also used in aspects of intellectual property to safeguard the ideas of the people involved, the parties involved. Thank you.
Thank you for your wonderful contribution. Mr. Godwin Kelechuku, please, can you speak? Mute your mic and speak. Mr. Godwin Kelechuku.
Okay, good afternoon, everyone.
Good afternoon.
To the
Please
best
go
of my
ahead and speak.
all right. To the best of my knowledge, where ADR can be applied is also when it comes to international affairs. Like, for example, when a sovereign nation has an issue with another sovereign nation, they normally make use of ADR techniques to resolve the issues. Because although I can't remember the particular law in Nigeria, but you cannot actually, if a foreigner, especially an ambassador of a foreign nation, comes into Nigeria and maybe defaults or goes against one of the laws binding in Nigeria, and is found that he actually committed a crime, the Nigeria cannot prosecute that ambassador. Instead, they make use of ADR technique to settle with the foreign nation on certain matters.
Thank you, Mr. Godwin, for your wonderful contribution. Ms. Marianne Ibrahim, please, can you go ahead and speak? Please, Marianne Ibrahim, please, can you go ahead and speak? Okay, gentlemen, let's forge ahead.
Good day, my please. I have a reply as well.
Gentlemen, please mute your mic.
So I think let's go ahead. And please, I think anyone raising their hand should, if we're not going to, if you're not going to say anything after now, just so that we'll know the new persons that will raise your hand the next time we're asking questions, so that we will not keep calling on the same persons. So we go over to the topic, the main topic. The other ones were the introductory part and all. So application of ADR in key sectors. Just like what, in fact, I learned from the other guy that just said, that's why you see, we can learn every day and all, and it's always good to share your opinion. That's why I wanted to be interactive. I did not actually add the sovereign nations here, and it's actually true, because one of the reasons why it's even good, because at that point, they would know which law will guide that particular dispute. That is why ADR is most effective there. Because when two countries come together, they need to use ADR to resolve that dispute. Because using court, okay, which court will they go to? And even the courts that for the national and international courts, they have certain jurisdictions in terms of subject matters they go for, which is why sovereign nations still uses ADR. So thank you for your beautiful contribution. It shows that we are all following. I mean, it's a great thing. Even the other person that talks about, what the other person even talked about, different things, like I learned a lot from you, and it's always good to have it interactive like that. So moving forward, alternative dispute resolution has found significant application in various sectors of Nigerian society. So each sector adopts ADR mechanisms differently, depending on the nature of dispute and the needs of the parties. So for commercial disputes, commercial transactions are prone to contract breaches, partnership disagreements, and debt recovery issues. So for these ones, arbitration and mediation are widely used in resolving business disputes. So for commercial and business disputes, arbitration and mediation. So what do ADR provides, or what's the importance? Why do they even want to use this? For quick resolution to prevent disruption of business operation. Like I said, sometimes if you go to court, let's say you're trying to do a transaction or there is a quick issues, breach of contract and all, you will have to be wasting time in court and your business is at the halt. So for quick resolution to prevent disruption of business operations, for confidentiality, we all know that business ideas are not easy to get every day. And so for confidentiality of your own business, you don't want to sell out your ideas and everyone to people. So for confidentiality reasons, arbitration and mediation is most resorted to for commercial disputes. And also expertise, like I stated before, expertise in that skill is the reason why for commercial disputes, ADR is necessary. Many Nigerian companies now include arbitration clauses in contracts to ensure disputes are settled privately and efficiently. So most times they try to, so that in case the other party wants to go to court, it starts from even the contract. So the contract even states that this is a method we're going to be using to resolve our dispute. So it is clear from the beginning. And if you check most commercial contracts, they always have arbitration, which shows that that is what is most applicable in that sector. So we'll move over to the next sector, labor and employment disputes. Dispute between employers and employees, wrongful dismissal, wage disputes, or trade union matters are often best handled outside courts. They can use different means, conciliation, arbitration, like labor, most of the time, labor unions are not, it's conciliation they use. They just bring someone who can suggest a settlement mechanism. If you see, most of the time, they have meetings with the government, parastatals, and or people in charge, and someone will be there. Sometimes it's even the people in charge that will also bring a settlement for them. Then they look into it and they come into an agreement. Because if they go to court, you see, imagine all those ASU strike. Imagine they went to court, but then there was still a settlement that happened even while the court was still succeeding, just so they will have some sort of things will go on. Because imagine the students are in school for like 1 year, 2 years until they resolve. That's a lot of disruption of the activity. So for labor unions, employment disputes, imagine a worker having an issue with the boss, he can't go to court because he is currently under the employment of that worker. So what most often happens is mediation and conciliation between the parties, between the workers, just so things can happen fast and you don't have any delay and your life move on. So we also have family and matrimonial disputes, issues such as divorce, child custody, inheritance, succession. All these things are sensitive, and you don't want to put, the worst thing you will do is to put your sensitive information outside when there are alternative way in which you can actually resolve it. And for continuous relationship, because most times, in fact, if you have a child, most of the time, it is not good because it is a stigma, or should I say, a trauma for that child. Some people even put their child as witnesses. Imagine you remember the child will just be crying in court. So it is always good if you can to resolve things amicably. Even for divorce, if at all you want to do a divorce, sometimes there's a settlement. If you want to really go through the court process, some people don't, instead of bringing all their things to court, they do settlement outside, then give the court, just like they call it consent judgment. So when two of them settles and write out that thing out, just because they want the binding effect from the court, that terms of settlement will be adopted in the court as what will guide them. Instead of the main suit where you call the witness, where you call this one, they start bringing all their WhatsApp text message, where the recordings are the one that maybe the man is violent, pictures. All those things are some things that if the child, maybe a child's friend is growing up and they want to use that thing to blackmail the child, or different, maybe not blackmail, just to taunt the child, it can go and carry that public record and show, which is a traumatic experience. So most people do not like going to court for sensitive issues as that. You have inheritance, succession, several things. Even some people just even leave it because court said a lot of time for this succession, if you are mostly in the eastern part, you see people even dying because they didn't even use the method that will make, when you use mediation, conciliation, they try to see from both sides and they try to resolve it amicably so that one party will not be angry and then cause harm. Because sometimes they're giving court verdict before you know, the other person that won will die, or the other person. So a lot of people just leave it. But if there are ways in which you can do it just so that harm will not be done, they resort to it. That is why most often than not, for family and matrimonial disputes, they use ADR. Mediation and conciliation are more effective than litigation. It promotes amicable settlement and reduce hostility, protect the privacy of family members, allow flexible solutions tailored to the family circumstances. Also, like I said, this mediation, you can get a family expert, someone that knows this thing. Like when she sees it, you know that, okay, this is the reason why this is happening, and also she can intervene. But if you go to a court, maybe you go to a judge that is egoistic, that is a family man or cultural man, obviously, some judges even believe, you'll be surprised, some judges even try to even, are also violent. So imagine going to meet a judge that will be on the man's side. So that is why most times people use ADR. So because they are not sure of who they are going to meet in court and which side, and or even if we know that judges are should I say they are neutral, but then we are all Africans, and also it's always good to still use someone specialized in that area. So ADR is most is effective more in family area, the key sector as family. So we go over to intellectual property. Intellectual property dispute also, ADR is being used very well. So the Nigerian creators are actually increasing by the day. In fact, currently, I feel Nigeria is one of the highest countries with a lot of creators. You see content creators, because it's true that people are tired of the 9 to 5 and all. So even professionals are actually content creators. They are bringing, and you can protect all this things. So what happens when your idea is being breached? People don't even know about that idea. Imagine Coca-Cola wants to, Coca-Cola has this trade secret. The trade secret for their unique You know, Coca-Cola, the taste of Coca-Cola is not everywhere. Even if everybody tries to do that cola, it is different taste from the Coca-Cola. So when they protected that trade secret, and imagine they now saw someone using it, you will not even be surprised that perhaps they've had such kind of dispute, but they did it discreet. People did not know. But if you come to the open, you must bring evidence of your own trade secret, actually. They have to compare the trade secret and the other trade secret. It will be in the open. So that is the reason why intellectual property disputes are hardly going to court. And even when they go to court, it is the fastest procedures they use, complaints. But most people, most creators do not want to go to court because it even affects some of their royalties and all. So for intellectual property dispute, ADR is most effective. So particularly mediation and arbitration is preferred because it protects its confidential business information and it protects their royalties. It provides, please unmute, mute your mic, please. Ishin Nkadi, please mute your mic. So for intellectual property disputes, we know that ADR is most applicable in that area. It protects confidential business information and royalties. It provides speed in industries where delays can cause financial loss. So we have the word WIPO. In fact, it is very peculiar because even in the IP sector, they have their own small resolution area. Like we have the trademark ministry, when there's an opposition, they don't go to court immediately. They come to their segment. They have a, should I say, mini dispute resolution center. They bring the two parties. You know, in trademark, you publish, when you do the publication, and then there's an opposition. When the opposition comes, they invite the two parties. They will say, okay, this is what happened, this is what happened. So they will quietly remove their name or remove their logo because they are infringing on the other person. You don't find all these things in court because they are, shall I say, they are sensitive information that should not be released out there. So the IP organization as a whole has their own way of doing things. That is why intellectual property disputes are hardly going to court, except it becomes something that is that cannot be resolved amicably. Then it goes to court. But IP is one area that ADR is used very well in. So the World Intellectual Property Organization recently launched ADR schemes in Nigeria, offering structured resolution of IP disputes. And even the WIPO the World Intellectual, they try to involve in different nations' disputes regarding IP, the process of application that you use to resolve that dispute. So another key sector is the international trade and investment disputes. As Nigeria engages in cross-border trades and attracts foreign investors, disputes often arise between states and investors. So investor-state disputes are resolved through international arbitration, often under framework like Convention and New York Convention. So different things, there are different arbitration sectors that amicably resolve international trade disputes. So what are the advantages? Neutrality, avoiding home court advantage, global enforceability and of arbitral awards. Nigeria has been involved in high-value international arbitration with the oil and gas sector. So another key sector is the community, land and environmental disputes. You have land ownership, boundary conflicts, environmental issues. You have the Niger Delta issues. I don't know if you know when the government tried to bring the Niger Delta, those people that they feel they are, should I say, marginalized or they are not well taken care of. Most times you hear dispute, it's not court. They actually come together and resolve amicably. So those environmental disputes, community land, several things that cannot be taken to court, else it will escalate the whole issues. So the government tried to even bring these stakeholders in this part to come together and resolve. So what are the advantages? It helps reducing communal clashes. providing cultural acceptable resolutions, encouraging dialogue between oil companies, host communities, and government agencies. So that's one of the area that ADR is very effective in. That's one of the key sectors. Then we have emerging sectors that are coming up: the tech, sports, digital economy. So sport law, dispute resolving involving contract, sponsorship, doping cases, and player transfer. Those ones most times, because it's coming up, it's a new area actually. So most often than not, they use the ADR method, the technology and fintech. With the growth of e-commerce and digital contracts, especially online dispute resolution, is becoming vital in addressing cyber disputes. We have the entertainment law, all these areas that are new, most often than not. In fact, there are some areas there that has not been adopted in the Nigerian laws, actually. So such kind of disputes like that there is no direct statutes. Yes, they are creating, a lot of things are coming up right now, and we need to keep amending our laws to catch up. So such areas like that, it's only ADR that can come to help in such disputes. So I will leave the floor now for just to know if people are catching up and all. For any other observation, contributions, and I can take questions also from here. So the facilitator will take it.
Gentlemen, if you have a question, just raise your hand, please. Okay, gentlemen, if you have any question, just write it down on the Q&A box, please.
There are legal procedures that you can actually follow to, express your grievances or prove the point. I took just online, in the air, in the floor. I know that we don't have to very easy. So if you don't have to have to but I'm that we now normalize that real people verified. Come on, do this. You have to prove.
So you can drop your questions. The facilitator will read it out. So I will be taking a few questions now.
Okay, number one question that we have here says, in a situation where one party insists on alternative dispute resolution, while the other party insists on litigation, which one should prevail or be encouraged by a solicitor?
Well, in answering that, I would say, first of all, ADR or litigation. If one party asks for ADR and the other person asks for litigation, that's why it's always good in every contract that you insist on the area in which the disputes shall be resolved. And the truth is that people have to come to a resolve. They have to pick one, because if one party says litigation, the other party says dispute resolution, maybe two of you will now say, okay, maybe you start with dispute resolution. If it doesn't work out, then you go over to litigation, because I think that the two parties will want to be heard. Since it has not been included in the contract documents, then it can start with the dispute resolution, the alternative dispute resolution first before the litigation. But that should be what will be applicable in that scenario. But that's what I stated initially. For every contract, there is always a clause for resolving disputes, which parts should be used, which area is it litigation or ADR that should be used? Most contract has that clause. So if it is not included, then there will be an issue actually. The two of you will now know you have to agree on the particular one, or you start with ADR, and conclude with court. That should be an attempt to the answer that I think will be appropriate in that scenario. So let's go over to the next question.
Thank you, Mr. Lillian, for your wonderful explanation and contributions.
So I think
okay, the next question is, in issues where in a mediation, the issues scale rather than being solved or reduced, is the mediator allowed to offer solutions, even if it is not conciliation, just to resolve these issues?
Just like the definition of mediation, I stated that they only help the two parties to resolve. Obviously, even in litigation, they always ask that, have you tried we all know that in the end of every dispute, sometimes, most often than not, it is not binding. So because of that lack of binding effect, for mediation, when we see that, okay, this thing, it is getting very tensed, then those parties will most likely go to court. So it is the mediation, ADR most times is just for disputes that we know that, okay, can easily be resolved. Two parties can come together and look at this issue and see it. But when we see that, okay, the two parties are not settling, it is not your work as a mediator to actually enforce anything or tell them solution, because you don't even really know the solution that is most applicable. Some of them just want to be right. This one wants to say, oh, you are wrong. I will never say I'm right. You're not going to give me. So those kind of disputes are disputes that I know that, okay, is way tense than just a mediator trying to intervene. In such scenario, you can actually advise them to actually finally go to court, actually. That should be the answer to that question. I hope I've answered you, though. So we'll move over to the next question.
Okay, thank you, Mr. Lillian, for the wonderful answer. The next question we have, good afternoon, ma. My name is Oluwanifemi. Okay, my question is this. What do you have to say about the arbitrarity of intellectual property disputes? Since we understand that certain IPRX, like patents, are largely state-given rights and have a wide effect across the country. The so-called ego ones effect. So how do we think ADR navigates those challenges to remain applicable in intellectual property?
If I can understand this question, it's quite lengthy and it's a bit vague, but I can understand the context. I'm thinking that you're trying to ask like the court issues, if they come into the intellectual property, how can ADR help? Okay, so since we understand that the certain IPR like patents are largely state-given rights and have a wide effect across the country, the so-called ego ones effect. So how do you think that the ADR the question is a bit confusing, but let me just clarify something. Patent is the protection of your idea. It is your own idea. Not, yes, I know, understand that the state gives you legal ownership for that idea. It's not even like you still have the originality. The reason why I always encourage that people patent or go for this registration is to have an evidence, is to have documents to prove that they are the owners. If not intellectual property, you are the original one. Once it is established that you are the first person who owns that idea or who owns that particular trademark and all. So you only go to the particular registries involved, like the patent and trademark registry. You can now go to protect that your idea. If you want to do copyright, go and copyright it. So it is not like state giving. Yeah, it is your own. It's just that the state only gives you legal title or legal ownership for that your particular idea. So why I'm saying that ADR is most effective is because it is a confidential, like it is like an idea, because ideas don't often come and you go to court. Court's like a public environment. So when you spill out those information that are very useful for you commercially, it affects you later. So that is the reason why ADR is more suitable to protect your company, to protect your idea, to protect your logo, to protect that your intellectual property. So if I'm just trying to be more general in trying to explain this, even if I'm not understanding the question per se, but I hope you'll be able to pick something from this explanation. Thank you.
Sorry, is it just me or is it okay?
Yeah, so let's take this last question and go over.
Okay, the next question goes this way. Since mediation and conciliation are not binding, what happens if one party goes contrary to their agreement?
It seems people like binding. The truth is that mediation and conciliation are informal ADR mechanisms, and they are used most times in disputes that are like in the beginning stage that can be resolved. You can't force in conciliation, in the mediation, you can't force a mediator to bring something at all. When it goes, obviously, these are just preliminary stages of disputes. When it goes higher, you obviously need something binding to hold the person. So you will resort to something else. You can resort to arbitration or you resort to going to court. But mediation are just like, why they always emphasize on ATR is because there are some little disputes that do not even really need courts. And those ones can be resolved from mediation. Like you see family disputes, maybe the man did not give money to the house, all those kind of disputes like that. You see that it can be resolved through mediation, yes. So those kind of little issues, but then you can't say there are some issues like maybe this person stole something or crimes and you want to be doing it through mediation or conciliation. There are some, yes, even if I know that there are some segments, some sectors, key sectors that ADR is applicable, not all disputes can actually go through ADR. You have crime, several disputes cannot actually be done through ADR. So once it cannot be resolved through mediation and conciliation, then you need to have a particular resolution that is more binding. It's not, you mustn't stick to that. After it doesn't work through mediation and conciliation, you move over to a more binding. Let me take the other one.
Okay, the next question. Please, is mini trial a form of ADR? And if so, can you talk about it?
I'm trying to understand mini trial, because mini trial, you have to maybe ask the question. If I'm to understand mini trial, should I say, like, I'm just trying to picture during that COVID-19 when people told people to come out and to not come out, and they came out, there was like a mini court there. It is not ADR. Those mini courts that they try to put emergency, like several court, the judges, there's a judge there that will just give the final verdict there and all. It is still court. So I'll accept you explain what you mean by mini trial, but that is still a court. So how does the principle of confidentiality operate differently?
Okay, let's just take one more question. Okay, Pastor Lillian, the question goes this way. How does the principle of confidentiality operate differently in mediation and arbitration?
How does the principle of confidentiality operate differently in mediation and arbitration? All of them are actually confidential, but I think for confidentiality, it is hard to actually differentiate the level of confidentiality. It depends on the person you brought as an arbitrator. I would say in mediation, most times they try to bring an expert in that field. If all of them are actually confidential, confidentiality means that that person you are telling that thing is a confidant, and the discussion or the sensitive information still stays in that circle. So arbitration is still one of the areas that you can say, okay, the thing is, it has not gone out. Even if I know that sometimes some arbitration resolution area is actually more, I would say mediation is quite more confidential because it is not as formal as arbitration. Arbitration has a binding effect. Therefore, they try as much as possible to bring a lot of people into it, that bring the arbitrator. Sometimes there are even like 3 or 4 arbitrators there. But in mediation, most times, because it is very informal, mediation and conciliation are like very informal. So they just bring maybe one person to hear the thing. So in terms of confidentiality, mediation has more, it's more confidential than arbitration, but the both of them has confidentiality and it is not done in the open. I hope that answered the question. I saw something new. That's good. I saw that miniature. What's the next one?
Okay, Ms. Lillian, please can you go ahead?
So enough of the plenty questions. I see that you are very active, and also I would like us to complete. We don't have much again, so that the floor will be open to all questions, contributions, and I will also ask my questions to show that you all have been listening. It's a very interactive one, and I like the fact that everyone is engaged, asking different questions. That shows that I am saying a lot that resonates with you all. So let's go over to challenges faced in the application of ADR in Nigeria. So while ADR offers clear benefits, several barriers limits its full effectiveness and acceptance in Nigeria. Understanding these challenges help identify areas for reform and capacity building. So what are these challenges? Lack of awareness and public acceptance. So many people don't even know what ADR is actually. If you are out there, you say, everybody say, go to court, go to court. A lot of people don't even know that This small family dispute, you can actually go to a mediator. Why carry your family issues to court? Then they will not be neighbor in the court. They will be this one because their matter they even person will not like you go they court. So it is not good. So, but some people don't even know. So many Nigerians, especially at the grassroots, remain unfamiliar with the formal ADR processes like arbitration and mediation. So they only see litigation as the real justice, as the actual justice. They'll say, I'll sue you to court, go to court. That's what people say every time, but that's because of lack of awareness, which is one of the challenges the application of ADR is facing. So enforcement of ADR outcomes is also one of them. Arbitral awards are binding, yes, but the enforcement is usually weak. It's still weak in Nigeria. One of the reasons why it is weak is because even the courts try to even make these awards weak. Like you go to court, some people will just go to court after the contractor says you're going to resolve to arbitration. They go to court and set aside because the truth is that the court is higher than this. So when you go to court, they can actually set aside the application. They can set aside the award. They will just set aside depending when the court, depending when verdict is given in court on that matter. So some people, after not being satisfied with the ADR way, they go to court. And when they go to court, immediately they set, because normally when you are going to a higher place, like from court of, if you are going from federal high court to court of appeal, you must set aside that judgment. So that's what happens. And when they set aside that award, that shows that there will be no resolution. Those people will still do what they want to do until the court gives a judgment. So you can imagine when they will now set aside the award and the court takes over 3 years before they give the judgment. That is part of the challenges they are facing right now. All those certain applications that are moved in court, making the ADR non-effective. So mediation and conciliation agreement are non-binding unless converted into consent judgment or contract. Like I told you, in family dispute, most people want to go to court, but if you want to go to court, just go to court to get the final verdict. So when you do consent judgments, it's adopted in, when you do consent, they have settlement. There's a terms of settlement you give to the court. That terms of settlement is adopted by the court and it comes to consent judgment. It is one of the challenges because it shows that mediation and conciliation don't stand on their own, but then it is still one of the features. It is also one of the challenges because you must still resort to court sometimes to make that dispute, that settlement you have done, binding. So shortage of skilled personnel and practitioners because of, I think this thing is kind of intertwined because of the lack of awareness, and people don't really resort to ADR. Then a lot of professionals don't even want to get qualified in this ADR segment because if you get qualified, how many people will want to come to meet you to resolve their dispute? So therefore, there are shortage of skilled practitioners in this field. So some practitioners treat ADR as formality rather than a specialized process requiring skill and neutrality. Lack of consistent professional standards undermine confidence in ADR outcomes. So because of this, people don't usually come, and then it is a challenge for ADR application in Nigeria. So we also have court interference, judicial attitude. Despite the Arbitration and Conciliation Act, Nigerian courts sometimes interfere excessively in arbitral proceedings, just like I stated before. So courts may entertain appeals or applications that delay enforcement of awards. Some judges still prefer litigation over ADR, slowing its adoption. So it's part of the challenges. Corruption and lack of neutrality. ADR is meant to ensure fairness and neutrality, but in practice, allegations of bias, corruption, and undue influence sometimes arise. Sometimes they bring mediators that is on one side. There are several things that happen, and then the resolution is not final because corruption is now into it. The person that brings the arbitral award has been bribed and all, which is a general issue affecting all sectors, even in litigation. So it's also part of the issues and challenges for corruption in Nigeria. So I will just conclude generally And I'll leave the floor open for final questions, and I'll also ask my questions. And because we've actually gone far in time. So let me just read this. Alternative dispute resolution has evolved from being a mere alternative to litigation into a vital instrument of justice delivery in Nigeria. Its application across diverse sectors, commercial, labor, family, intellectual property, international trade, community, and emerging industries demonstrate its flexibility and relevance to the country's legal and socioeconomic landscape. By offering speed, confidentiality, cost effectiveness, and preservation of relationship, ADR addresses many weaknesses in Nigeria's conventional court system. However, its effectiveness depends on overcoming challenges. So these challenges must actually be overcome if ADR wants to be fully effective. Lack of awareness, enforcement issues, institutional weakness, and cultural resistance. So when all these are addressed, it will make ADR a safe haven for all dispute resolution. So that will be all for now.
Okay, thank you so much, Barrister Lillian, for that insightful, wonderful, powerful section. I'm sure everyone has gained a lot from your experience and practical advice. So, gentlemen, we'd love to open the floor for you to write down your questions in Q&A. And okay, if you also want to talk, you can actually raise your hand so we can take some questions. Then we'll also pick some questions from the Q&A. And please, let's try and make it as interactive as possible. Ms. Mmesoma, please go ahead and ask your question.
Hello, good afternoon. Thank you, Ms. Lillian. The session has been really great. And I just want to ask, when parties enter an agreement within themselves, is it when they go to court to report the settlement? Because I go to court and I hear report of settlement, the case is for report of settlement. So I want to know whether that report of settlement is like when parties have agreed within themselves, they will not take it to court to get it as to make it a consent judgment. Or I just want to be clarified.
It's just like you are asking the question and giving the answer, but actually that's what it is. They settle with any means. Sometimes they use mediation, sometimes they use conciliation, sometimes they even use negotiation. That's just two of them, no third party, or they use conciliation. So however they use to settle and bring that terms of settlement together, the court doesn't ask. But that is just know that one is ADR plus court. Yes, they can merge. Sometimes they start with ADR and they want the binding effect from court. They don't want maybe arbitral award and all. So they can use mediation to get their consent, their terms of settlement. They now file it in court as a terms of settlement. Then the court, when they adopt that terms of settlement, it becomes a consent judgment. That's the two parties. The court will not do any other thing but read out the terms of settlement that the parties has actually stated. So when they adopt that terms of settlement, it is called consent judgment. As two of you has consented to this settlement and it becomes my judgment. So that is what becomes consent judgment. I hope that has answered your question.
Thank you, Barrister Lillian.
Yes,
Mr. Atanda Elijah, please. Okay, Mr. Atanda Elijah, please go ahead and ask your question. Mr. Atanda.
Good afternoon, ma. Please, ma, it's actually Elijah Kwong. Thank you very much.
Please go ahead.
Okay, ma, I wanted to ask, although ADR is not it's not a kind of should I say, like, means of solving problems whereby we go to court. It's not litigation, but can we say that ADR in Nigeria in particular is actually adversarial in nature? That's my question.
It's actually what? I didn't hear you well.
Like I'm saying, is ADR in Nigeria actually adversarial in nature? That's just the question.
Well, I would say it is not adversarial per se. And sometimes it can be, but like I told you, ADR is like the beginning part. So when it becomes so tense, the mediator will not really have much to do. And those kind of situations where, in ADR, is dispute that that, okay, settlement can come out from these two parts. But adversarial system, most times two persons don't want to agree. Like the other party wants to have, no one wants to say they are wrong. Do you understand? So if it becomes that tense, then mediation or conciliation will not work. They need more binding effects from the courts. So I hope that will answer your question a bit.
Good afternoon, Barrister Lillian and everyone. So my question is on my question goes thus: can ADR under any scenario, can it come in for a murder case or for a criminal case? Maybe between family members or something. Can it come in?
So thank you. It cannot. Like I said, if you were listening to when I stated it, it cannot come in. There are some disputes that are like compulsory. The state makes it compulsory that it goes to court. Crimes cannot be done in the room. Like crimes cannot be resolved. It is a murder. The state takes it up. And they don't want member to come and report that issue because it is said that we're all citizens and the state still owns us in a way. So when someone is killed or whether you even take it to court or something, if the police gets to know about it, they take it up. So those are part of, they say there are key sectors for ADR, crimes and all other things like murder, felonies, and all those things. There are key sectors for litigation. They cannot come under ADR. So I hope that answers your question.
Yes, ma'am. Thank you very much, ma'am.
Thank you, Ms. Lillian.
Yes, good afternoon, ma'am. So my question is based on the AICMC
Please mute your mic, please.
Yeah, I can hear you. I can hear you. Go on.
Okay, so my question is based on AICMC training and NICAP training. Like, before I can be a mediator, a conciliator, do I necessarily need to go for those trainings?
Of course, you need to, because it is a certification. You can't just get it without being trained on it. It's a profession also. You are part of the association, like AICMC. I know they do it in university, they do it in law school, even normal persons, accountants, or even outside law school. It's just that I know that those are like the cheapest areas you get it from: university, law school. So you go for their training. The training is actually not more. Sometimes it's like 2 weeks and just like 3 days or 4 days of training, and you get the certificate during the induction. So you must go through those training before you become an associate member in those organizations.
All right, ma. Thank you, ma.
Good afternoon, ma'am.
Good afternoon, ma'am. Good afternoon, ma'am. You want to expose is very cold.
Please, can you unmute your mic? Unmute your mic,
Good
sorry.
afternoon, ma'am.
Okay.
Okay,
Please
ma,
go
I have
ahead
a
with your
question.
question. Go ahead.
Okay, ma'am, my name is Uwemedi Modofia from University of Uyo, and my question is based on mediation. So, what processes are being determined how like decisions like that is judgment in a mediation is being upheld, so that let it not be that during the mediation, like we come up with a judgment, then the other party does not take that judgment into consideration. So what will happen then if such party does not take like the judgment into consideration?
Can you repeat your question?
Like
Thank you
my
so
question,
much. Okay. So if I can understand your question, you're saying that if one party doesn't agree with, it's not judgment, and if you were there from the beginning,
like
mediation,
an award, man.
it's not even an award, is for arbitration. Mediation, the mediator just assists the two of them to just resolve. The mediator doesn't even bring an award per se or bring a settlement criteria. So in mediation, they just try to make sure that the two of them has come to a settlement ground. They just hear the different issues, and the mediator that is skilled, like most times happens between couples or family disputes. Obviously, the mediator cannot tell the family the final say. The mediator can only use her experience to tell the family what she thinks and what the issue, just an expert to be there while two of them are both pouring out their minds. So that mediator will now say some things that will now help the two parties to resolve, but not per se give an award or give a final say. In the end, the two parties in a mediation has the final say, not the mediator. So if it becomes higher than that, then they resort to a more binding means of resolving the dispute. So I hope that answers the question.
Yes, man, understand.
Okay, thank you,
Thank you
Ms.
very
Lee.
much.
Good afternoon, ma. Good afternoon, ma. Good afternoon, ma.
Okay, the time is already up and we will soon go off. So we'll just read this last question. Okay, ma, from the Q&A question part, the question goes this way, ma. I have a question. Can ADR be used in the oil and gas sector, especially with issues of oil spill and breach of contracts, etc.? Yes, like I stated initially, oil and gas sector is actually part of the key sectors for ADR, actually. Even in this Niger Delta issue and all, they've been using conciliation a lot of times in that area. So yes, it is also part of the key sectors for ADR. So the questions are a lot. So my LinkedIn handle will be dropped so that you can also reach me to I will answer all your questions, and also just I will give access to my personal profile so that you can start, because right now the scheduled time for the meeting is already up. So in case you have any other question or you want to reach out to me on this topic, just let me know and my handle will drop. You can text me there. Thank you very much. Okay, Ms. Lillian, thank you so much for that insightful, engaging, powerful section on alternative dispute resolution. Your expertise and practical insights has truly added immense value to our OVIP experience. So gentlemen, please, let's show our appreciation. Drop emojis, clap in the chat to thank our guest speaker. It was so impactful. It was truly impactful. So gentlemen, as we wrap up today's section, I encourage you to take the lessons learned and think about how you can apply them in real life scenarios. Remember, participation doesn't end here.
Stay curious, stay engaged, and continue to make the most of this internship. Thank you all for your active involvement. Okay, we look forward to seeing you in the next section of our OVIP. Please don't forget to connect to Ms. Lillian via her LinkedIn page. She will drop the handle now. You can send in your questions to her. Okay, thank you guys. Do have a wonderful day.
Thank you, ma'am.
Thank you, ma'am.
Thank you, ma.
Thank you, ma'am.
Thank you, ma'am.
Thank you, ma'am.
Thank you.
Thank you,
Thank you, ma'am.
Thank you, ma'am.
Thank you, ma.
Thank you, Ma.
Thank you,
Thank you,
ma'am.
ma'am.
Has already been dropped on
you,
the
ma'am.
comment section. You gentlemen, please, we have dropped Ms. Lillian LinkedIn handle on the chat box, so you can follow her and send in your questions to her. Thank you, everyone, and do have a wonderful day. Email.